Thank you. Hello and welcome to our webinar, Employment Issues That Should Keep You Up at Night. I'm Katie Yen, our Director of Business Development for Jones, Skelton Hochuli, and we're pleased to have you with us today. Thank you for taking the time out of your day to join us. Before we begin today's webinar, I'd like to review just a few housekeeping items. Please note that as an attendee, you are part of a larger audience today. All attendees will remain in a listen-only mode. Currently, you should be able to see our PowerPoint slide, as well as a dashboard and a live video stream to the right of your screen. If you are experiencing any technical difficulties during the webinar, please contact the WebEx Help Desk at 866-229-3239. And that phone number has also been posted in the chat dashboard. While we are on a listen-only line, we do encourage you to ask questions throughout the presentation via the Q&A tab on the dashboard. We are responding to your questions throughout the presentation, but we will also leave some time for Q&A at the very end. If you are unable to address your question during the presentation or at the end, I encourage you to follow up with either myself or Steve or Gordon. We'll be happy to address your questions. You'll see their contact information posted on the final slide. This is being recorded and will be available on our website. You will receive a link to this recording via email. At the conclusion of the webinar, you will be redirected to our brief online survey. We certainly encourage you and appreciate you to take the time to provide us with the feedback which enables us to further enhance our webinars. Now let me take a moment to introduce our presenters. Today we have Steve Leach and Gordon Lewis. Welcome. Steve and Gordon are both partners with the firm and members of our employment law practice group. Both spent the majority of their 20-plus years legal careers representing employers. Without any further delay, I will go ahead and turn this over to Steve.
All right, Katie, thank you very much, and thank you all for joining us. We're trying to decide if we ever really had a career in TV broadcasting, because if so, this is what it must feel like. Yes. And we hope you enjoy yourself today. Please do respond with any questions you have, and we'll try to make this interactive. By the way, I'm going to answer the first question that you're thinking already. Yes, we do have a requirement that you have to be bald to be a male member of our employment group. And I'll throw out a question to you all, a little bit of a quiz. If, in fact, an employer like us did have a requirement that for men you had to have a receding hairline or worse, would that be a violation of any employment law? Think about that. We're going to try to get through a lot today, and the point is not to drill deep into issues, but to touch on issues so that truly, to follow the title, things that you should worry about, things that you should be concerned about. We have two groups of people attending today. We have employers, HR professionals, and we have claims professionals who handle employment matters from the insurance perspective. So our point is to just touch on things. We know employment litigation is getting more expansive. There's more litigation, more claims every year. And our hope is that by just at least touching on some issues, it helps you manage it and recognize what you can do within your organization or in handling claims to better your success rate, and just realize that there are a lot of things that are changing in the employment world that are probably going to make things a little more difficult. Let's get into the ADA. The amendments by the federal government to the ADA regulations, the EEOC brought in final regulations for those amendments in 2011, and it changed significantly the nature of ADA liability. It didn't change the definition, but what it did do is it made it a lot easier for someone to be considered disabled to fit within ADA. So as you're dealing with employees or you're looking at claims, the question they probably aren't, their impairment isn't bad enough to be within the ADA. That defense is pretty much gone, or at least has been significantly reduced. So, when we're dealing with anyone who has a mental or physical impairment and is presenting that as possibly relating to their work, or you're considering how to manage that employee, you've got to understand that the ADA is probably going to come into play. An issue that's been hot with the EEOC is leave accommodation. They just came down with a $20 million settlement against Verizon Communication because they had a policy that if you've got so many chargeable leaves, you were disciplined, regardless of why you took the leave. And the EEOC said no, because some ADA folks who are disabled under the statute require leave as an accommodation. Remember, too, that sometimes the ADA requires leave beyond the FMLA leave. So a person goes on FMLA leave, says, hey, my condition is such, I still can't come back to work. You may need to give them that leave as a requirement. How much leave? Who knows? That's the problem. We can't give you a bright line test. It makes it a lot more difficult for you to claims, makes it difficult for us to evaluate claims. We've got to work together to decide when is to leave given the particular circumstances. Let's go to the next slide, please. Process, because more people are going to fit with the ADA. Anytime somebody comes to you with a medical issue, we got to make sure we're getting involved in the interactive process so we're complying with the ADA in that regard. That is critically important. So line managers, frontline managers have to be aware when somebody comes with an issue that's medically or mentally related, they need to consider getting it to the HR folks so that we talk about the interactive process. Professionals need to be considering, are these employers, did they engage in an interactive process with this person? And again, because more people are going to fit within the ADA, we have to be more involved in providing an interactive process with those employers. Regardless of liability, this is ADA liability by rumor. They don't even need to be disabled. In the past, you had to regard the person as actually disabled, meaning you had to regard them as being substantially limited in some major life activity. No more. The EEOC and the federal government have taken that away. If you have a person who you just regard as being impaired, regardless as to whether that you believe that impairment is sufficient to trigger the ADA, and you take some adverse action against them, you have liability. So the person may not even be actually impaired. They may not be actually disabled for the ADA. There may be grounds sufficient to find liability if you discriminate against that person. It's a big mine out there in this multiple minefield ADA world. With respect to the ADA, I wanted to mention random alcohol testing. This is also something the ADA is getting very active about. The EEOC has an enforcement guideline that says that random alcohol testing violates the ADA. I know there's a lot of employers out there, and for you claims handlers, a lot of your insureds that have random drug and alcohol testing as part of their workplace alcohol drug use policy. The EEOC is being very strong in saying that is illegal with respect to the alcohol part of the testing. We have a recent decision earlier this year out in Pennsylvania where a court said, not so fast, EEOC. In fact, they said they thought the EEOC's version of the ADA defied common sense. But in that case, those employees were involved in a steel mill. It was recognized to be a very safety-sensitive position. And there the court saw a need for random alcohol testing. So we're talking about restaurants, or we're talking about administrative employees that are not in safety-sensitive environments. You may not be able to use that argument to defend yourself. I think this is a potential time bomb for a lot of employers out there using random alcohol testing and may not even realize that it is a potential violation of the ADA. Could be a lot of exposure. So those are just a few issues of many you should all be thinking about and being concerned about with respect to the ADA. Pat Gordon.
And, I know that everyone watching thought that I was just the eye candy for the presentation. and of course,
they're right.
Why wouldn't you?
Right.
Why wouldn't you?
Right.
But I'm actually going to speak, and what I want to talk to you about initially are some issues regarding wage and hour law. A couple of pitfalls, one new defense in the wage hour area. And of the nightmare claims or issues that we're going to be talking to you about today, I think that this one is the biggest and the scariest. And that's because wage hour claims are multiplying like rabbits. As you can see, last year, for the last reported year, there were 7,064 wage hour claims filed in the U.S. It was a record high. It is double the amount that was filed over a year ago, and these claims resulted in $280 million in back wages being paid to over 300,000 employees. It is a big deal, and there are big damages that can be associated with these types of claims. You might have to go back 2 or 3 years for employees. You can have liquidated damages that would double the amount that persons receive, and plaintiffs' attorneys receive their attorney's fees if they are successful in prosecuting these kinds of claims. And so plaintiffs' attorneys now are looking for these types of claims. I heard a story last week about a plaintiff's attorney who had an intake form for prospective clients who come in for any reason. The intake form was 16 pages. 8 of them were devoted to wage and hour. plaintiffs' attorneys are really starting to hone in on this area of the law. And part of the reason is often there's no defense to liability. The evidence that you made a mistake is, right on the paycheck stub, and once a mistake is made, there's really nothing you can do. There are, when you're looking at a discrimination or harassment claim, all sorts of issues of credibility and fact, but if you fail to classify an employee properly, that's the end of the story. And under the Fair Labor Standards Act, individuals can be liable, not just the company, but the company owner or the supervisor who is responsible can be liable individually under the Act. So it's a real landmine, and there are just a couple of issues, a couple of traps, and one new defense that I wanted to talk about today. The issues are classifying employees, exempt versus non-exempt, because if you're making a mistake on classifying an exempt employee, that's someone who usually pays more, and so the damages that are associated with making that mistake could be huge. I want to talk a little bit about what I call overtime by BlackBerry for non-exempt employees, what kind of personal device use they can undertake. And then I want to briefly mention a new defense that was recently adopted by the Supreme Court that could give people something in their ammunition to guard against class action claims. We'll go to the next step. So again, classifying employees as exempt versus non-exempt is probably the biggest landmine for employers, because if you get it wrong, it's a huge problem. So there are a couple of things you have to meet in order to have a person truly be exempt under the Fair Labor Standards Act. First, they have to meet the salary test, and then they have to meet a variety of duties test. The salary test is fairly straightforward. You have to pay the employee a salary. Under the Fair Labor Standards Act, the minimum salary is $455 a week, and you can't deduct that salary for almost any reason. So if they're gone a partial day, if they're gone a partial week, you can't make adjustments in the salary, because if you do, you're going to lose the exemption. The tests are where things are more challenging. The major ones are what are called the white-collar exemptions: executive, administrative, and professional. And we'll talk about each of those. Go to the next slide. Now, the executive exemption is sort of the people who we call managers, the assistant manager, the shift manager, the foreman, those individuals. And many employers just say, well, if this is somebody who I give some supervisory authority and I pay them a salary, then they're exempt. But you need to meet the test that you see on the slide. And the first portion of that is that the employee's primary duty must be management of the subdivision. So it doesn't necessarily have to be the majority of the time in management, but it has to be the thing that is most important. So if you have somebody who's like a kitchen manager, they manage 3 other people, but the thing that they do most is cut the vegetables and prepare food, then even though they have some supervisory authority, they don't fit under this exemption, and they may not be exempt, and you might owe them overtime. The employee has to direct 2 full-time employees. That's 2 FTE, so a full-time and a part-time is enough. And the employee has to have the authority to hire and fire or make strong recommendations in that regard. So if you have a manager who doesn't know they have that authority, or they've never really made a recommendation on hiring or firing or some significant discipline, you may need to look at that to see if that person is truly exempt as a manager. There are lots of people who have an assistant manager title or a shift manager title or something along those lines who could be misclassified, and that can be a big problem. Next slide. The administrative exemption, those are the people who are doing sort of the back office work, the things that aren't in the production of whatever it is that you're making. Now, the thing to remember here is just because you have a bachelor's degree and you have an office job does not mean that you are qualified under the administrative exemption. And significantly, the person has to have discretion with matters and independent judgment with matters of significance. So if you have the person who is sort of 3 levels down in the IT department, 4 levels down in the HR department, 3 levels down in the accounting department, even though they're doing back office work, unless they have that independent discretion, they may not be exempt. Especially for accountants, this can be a real area of pitfall. And the next one is the professional exemption. These are people, this is an or as opposed to the ands that you had before, where the person's primary duty involves specialized and advanced knowledge, or their primary duty involves creative endeavors. the place where this can be a real trap is figuring out how advanced of a degree is enough. So for your social workers, for your junior accountants, for some of your engineers, while they may have a bachelor's degree or something along those lines, and they do work that requires a great deal of skill, it may not be advanced enough to qualify for the exemption. So things that you really need to watch out for and review your policies to see if you are qualifying your employees correctly. The next thing briefly is overtime BlackBerry. So if you've either misqualified these people exempt or you have people who are not exempt, you have to pay those individuals overtime for any hours that they work over 40, and you have to track those individuals' time. Well, now with the proliferation of iPhones and iPads and tablets and Kindles and all of the things that you have to get connected to the office, if you are allowing non-exempt employees to connect to the office and you're not tracking their time and you're not paying them for that overtime, then you're going to create problems. That's something that the employee is interested in pursuing or not. You need to make sure that for your non-exempt employees, you're very careful in the kind of access that you give them. On the bottom of that slide is the Allen versus City of Chicago case. That is a case where a police officer brought a class action under the Fair Labor Standards Act where the only allegation was that they weren't paid for the time that they spent responding to text via cell phones and being involved in responding to emergencies in that way that went over their allotted time. And the court threw out a motion to dismiss that was filed by the City of Chicago, and they just recently certified the class action. That's going to cost Chicago a fair bit of money. Finally, I wanted to mention a defense in class action cases that was recently recognized by the Supreme Court. If you have an individual who files a Fair Labor Standards Act claim and then wants to represent all of the members of the class, if a defendant says, well, you have a claim and here is an offer of judgment that takes care of all of the money that you could be entitled to under the Fair Labor Standards Act, that makes the claim moot with respect to the employee who's bringing the claim, and then they cannot represent the class and try to bring in a whole bunch of other people. So you should give thought to if you're, it looks like you have liability on the Fair Labor Standards Act and you have somebody who's bringing forward a class, you want to give thought to making an offer of judgment that gives that person complete relief, because that could cut off their ability to bring a lot of other individuals and multiply the liability. So the points that I wanted to make on the Fair Labor Standards Act are you need to check your job descriptions, you need to check your policies to make sure that the people who you think are exempt actually have the duties that would make them exempt. You want to review your policies on personal devices to make sure that you aren't giving employees who are not exempt the ability to make overtime claims. And if you have close calls on exemptions, you should get an opinion, a legal opinion on that, because if you get a legal opinion regarding an exemption, if it's a close call, you can get willfulness requirement that would allow liquidated damages, and so that can be a great benefit for you. I'm going to turn it over to the non-eye candy person.
Yeah.
We had one question come in real quick, Gordon. Let me ask you. So can an employee agree that their cell phone is not subject to overtime?
An employee cannot contract out of the Fair Labor Standards Act. Okay. So if you if you and your non-exempt employee says, well, look, it's going to be a lot more convenient for us to do some weekend responding over text, and we both agree it's okay, we both sign something that says it's okay, and I won't go after you for overtime, you're still on the hook, and 2 years later when the employee changes their mind, that's going to create liability. So it's not something that you can negotiate around. If they're non-exempt, you have to track their time, and you have to pay them for overtime, and that counts with respect to agreements and texting, even if the employee agrees.
Right, thank you. And please continue to send your questions in via the Q&A panel on your dashboard.
Let me just reiterate what Gordon said. Of all the things that we're going to talk about tonight that should keep you awake, this is the big one. There is so much hidden exposure out there. And whereas many of the things we're going to mention are undefined, where it's very difficult for us to give you a set opinion, how much leave is enough, what constitutes a disability. That makes it difficult because it's hard to answer the question. In this case, there's not a defense. There's no if or how you wiggle around this. It's, do they have 2 full-time employees that they're supervising? And so there's a lot of companies out there, employers are just simply mischaracterizing their employees and could be facing some really significant exposure. Let's jump into Title VII retaliation. This now, as of last year, retaliation became the most prominent of all the discrimination charges filed with the EEOC. And the reason we're seeing more retaliation now, and probably going to see more in the future, is the Supreme Court is making it easier for employees to file Title VII and fit within Title VII retaliation claims. Imagine that. Our government or our court system being hard on employers. It seems like it's the trend, and the Supreme Court has been doing this, starting with the Burlington Northern case in 2006. And no, retaliation is when when employer takes adverse employment action against someone who's been involved in protected activity, such as claiming that they witnessed harassment, being a victim of harassment, anything participating in an investigation of a Title VII claim. And that has been the traditional claim. There's 2 issues here. Did engage in protected activity, and then was adverse employment action taken? In 2006, the Supreme Court significantly expanded the adverse employment action. In the past, we used to say, if you weren't terminated or demoted or suffered a pay cut, it probably was adverse action. And that was a defense that we were utilizing with some success. The Supreme Court said no. It doesn't matter what employer does. We really need to look at, would it be the type of conduct that would dissuade an employee from bringing a retaliation claim? So, of course, adverse action is much broader. What if a person says, hey, I used to have a desk next to a window. I reported harassment. Now I'm in a cubicle in the middle of the room. I liked my window. And if they'd have been told I didn't have my view, I wouldn't have said that. Maybe that's enough. We don't know. Just another area where we have to say, not sure, and you've got to be careful of taking any amount of adverse action against someone who's engaged in protected activity. In the case, Thompson v. North American Steel, in 2011, the court expanded the nature of those who can bring a claim. Traditionally, it was the person who was engaged in the protected activity. In that case, you had 2 employees who were engaged. The fellow filed a sexual harassment charge, and just 3 weeks later, her fiancé was terminated. Normally, we would have said, well, he wasn't engaged in protected activity. He doesn't have a Title VII claim. Not so fast, says the U.S. Supreme Court. In fact, this court said, we're going to look at who's in the zone of interest. And in that case, it decided that a fiancé is, because if you could fire the fiancé, then you probably were going to preclude or chill the chances of somebody bringing a claim. Who's in the zone of interest? So obviously, fiancés are husband and wife, presumably, parents, siblings, nieces, nephews. How about if you had a really neat conversation with somebody in the break room the day before? Are they in the zone of interest? We don't know. There's going to be a lot of litigation on that, but it means for you as employers and you as claims adjusters, if you take employment action or if you're evaluating employment action against someone, you've got to look at all the folks they're associated with. And was any one of those people they're associated with engaged recently in protected activity? And if so, we have to evaluate whether there might be a Title VII claim there. Next slide, please. Employees realize that this is a tool. They're using it. They see the writing on the wall that their employment's in trouble. They make a claim. You have to be able to determine whether it's a real claim for retaliation or whether it's just a way to protect themselves. It's not a get-out-of-jail-free card, but you've got to realize that it's pretty easy to walk down and fill out a charge form for the EEOC, so you may be seeing some really boundless claims from people who are trying to protect their employment. How to avoid and defend. We have to work on our policies and training so that people don't retaliate. We have to consider associational retaliation. Who else is associated with the person we're considering taking employment action again? And we've got to document discipline. In some of these cases, we want to say, no, there's a really good performance reason we terminated or demoted or took some action. It's well documented. That's going to help us demonstrate it's not a pretext for retaliation. But folks, there's a lot of these claims that are out there. There's more today, and unfortunately, we're going to see more because the U.S. Supreme Court has opened the door for more people to fit within Title VII retaliation.
And Now, I'm going to talk to you a little bit about social media and the National Labor Relations Act. And probably to your disappointment, this isn't going to be a discussion about the benefits and drawbacks of Twitter versus Facebook and, what should be the primary, resource for your social media interactions. Instead, we're going to
Jordan, you are going to tell them about your Twitter page, right?
I will tell, that...
He has so many followers.
I keep that under wraps. Try to build that wall. But this is about, enforcement of union laws. And I know a lot of you are wondering, what does this have to do with me? Well, the National Labor Relations Act, the law that sort of protects union organizing and collective bargaining, applies to both union and non-union employers. And the National Labor Relations Board is taking a special interest in applying that law, the National Labor Relations Act, in non-union employer circumstances. I was listening last week to the general counsel for the National Labor Relations Board, and he was saying, essentially expressing the aggression with which the board wants to make sure that employees understand their rights. And one of those employees' rights is engaging in protected concerted activity. So now you're thinking, what does this have to do with social media? Next slide. Well, protected concerted activity is an employee's right under the National Labor Relations Act to talk to other employees about the terms and conditions of their job. So if two employees are in the break room and they're talking about their salaries, or they're talking about some policies, or they're talking about how mean their boss is to them, you can't discipline those employees for making those comments in the break room. Well, if you can't discipline the employees for making the comments in the break room, you can't discipline those employees for making the comments in the chat room. So if employees are on Facebook or they're on Twitter and they are talking about the terms and conditions of their job, that activity is protected and you can't discipline those employees for that. And not only is the National Labor Relations Board looking at the actions that employers might take against employees who engage in this conduct, they're looking at the policies that employers have that relate to the conduct. If your social media policy says, don't make any damaging statements about the company, or don't defame anybody, or, we want to make sure that you're not talking badly about other employees, the National Labor Relations Board could think that that's a infringement on employees' right to engage in protected concerted activity. And the Hispanics United case at the bottom of this slide is a case where one employee got on Facebook and was complaining about another employee in the workplace not pulling her weight. And a couple of other employees got on the Facebook page and agreed. The employee who was being complained about went and talked to the employer, and the employer fired all of the employees who were making these complaints. National Labor Relations Board said, that's protected concerted activity, and you have to reinstate all of these employees, and you have to give all of these employees back pay. So, the things that I want to make sure that you take from this portion is, you want to review your social media policies. You want to make sure that you're not inadvertently causing a circumstance where employees' protected concerted activity could be restricted. You also want to be careful about your confidentiality policy. If you have a general policy saying that employees can't discuss confidential information, General Counsel says that could be a violation of the National Labor Relations Act because they might think their salary is confidential. So you may want to think about putting in a clause that clarifies confidentiality. And you always want to be careful when you're disciplining employees for unprofessional speech. It's not protected if the employee is going on a rant on Twitter, but when other employees join in, it could be protected activity, in any circumstance. So those things that you really be thinking about when you're looking at your workplaces and your insurance.
Exactly. See? I will be filing charge. You were all witnesses harassing me. Harassment has liability taken a back seat a little bit in terms of its prevalence recently in terms of numbers of charges to claims such as retaliation. As this slide demonstrates, let there be no doubt that the potential exposure for harassment remains enormous. If you go on the EEOC website, you will see that on the same day, the 1st of May, just not too many days ago, their largest ever verdict from an Iowa jury who gave a $240 million verdict in disability harassment claim involving 32 employees. That very same day, the EEOC got a $20 million verdict in Florida for a sexual harassment claim involving 8 employees. A big problem. One of the reasons it's a big problem is that to this day, and this surprises me, every time I go into a workplace and start working with employers on training employees and supervisors to lower, risk manage harassment claims, is that people still think solely about sex harassment. You look at policies, and the policies say, we do not allow any form of sexual harassment. The training or understanding of what harassment is limited to sex harassment. Obviously, Title VII harassment is not limited to gender-based harassment. It is other forms of harassment, racial, disability, age, because we also have retaliation or harassment outside of Title VII. So we need to make sure that our people are being trained and educated so that they understand that conduct that is inappropriate goes beyond the realm of sexual harassment and fills those other areas as well. One problem that we're seeing or worried about in the future is how is harassment going to expand in the future? We talked about how retaliation exposure is expanding due to changes in the Supreme Court, how they're dealing with that issue. We have 2 possible ways that we see expansion in harassment claims. The first is the Healthy Workplace Bill, the grassroots effort to anti-bullying to the types of harassment that are illegal. If I sit here and bug Gordon during the day and I'm mean to him, which of course I'm off.
That happens every day.
Right. But if I'm mean to him, being mean to a person is not currently actionable harassment. They want to change that. They want to say if you're abusive to somebody, if you conduct yourself in a way with malice that a reasonable person would find hostile or unappreciated, they want that to be the type of action that can be a basis of litigation. And you can imagine that opens up a huge area of new potential exposure. Now, no state, by the way, it is an effort to add legislation at the state level, and no state has done so yet, but it's out there. The issue that is right on the tip of happening is the Vance v. Ball State case in the Supreme Court. We had argument on that case in November, waiting for a decision. As you all know, vicarious liability or liability directly to the employer for harassment generally arises when the harassment involves a supervisor. The issue in Vance is who's a supervisor. The circuit in that case said, well, a supervisor is somebody who can fire, who can hire, who can demote, who can promote, who can take discipline against an employee.
Like the Fair Labor Standards Act.
Exactly. Seems pretty reasonable. However, in that case said, no, the person who was being harassing me had some ability to tell me what to do. That should be enough. And it got all the way to the Supreme Court. And obviously, if they expand supervisor to mean any employee who has any seniority or any ability to point the person in the right direction and say, hey, go sweep over there, potential vicarious liability to employers goes through the roof. Surprising, our recent administration argued during that court case saying, it should be a very broad spectrum. Throw out the Seventh Circuit decision and create a very broad definition of who is in a supervisor. So we're going to have to wait and see. If the Supreme Court comes down the way the government wants and overturns the Seventh Circuit and gives a test that expands supervisors, the definition of a supervisor, we could see a significant increase in vicarious liability to employers on harassment claims.
I want to add one thing in the harassment arena that brings it back to the National Labor Relations Act that is something that I think many employers are going to need to pay attention to. Lots of harassment policies have these blanket statements saying that you must keep our investigation confidential. You can't talk to anybody about what you've talked to me in terms of the harassment investigation. Well, the National Labor Relations Board takes the opinion that if you're making a blanket confidentiality statement for employees in terms of discussing the harassment they might have been suffered or discussing the investigation, that could be blocking protected concerted activity, and that you'd be making some sort of individualized assessment in every occasion whether confidentiality is necessary in the investigation. So employers need to look at their harassment policies as well as your policies on social media and other things to make sure that you are not inadvertently blocking protected concerted activity, because that's a position that the National Labor Relations Board has taken, and it's something that they may that could cause liability when you're just trying to preserve the integrity of the investigation you're doing in a harassment context.
And thinking about what your policies say leads to the next point, is that we are continuing to see harassment as an issue, potentially because we're not doing a good job at what we need to do. We just think that the workplace has become enlightened through education, through training, through policy, and that people are acting better towards each other. And yet, if you look, the reality is that may not be happening. The $40 million case in Iowa was based on some horrific harassment of mentally disabled individuals in the workplace, something that you might have expected in the 1800s was happening now. $20 million case in Florida dealt with day-to-day sexual harassment, touching, sexual propositions for sexual activity in the office place. You'd say, okay, that I could see that on Mad Men, but today, yeah, we see it all the time when we are investigating these. And just in April of this year, there was a $700,000 settlement with the EEOC for an Ohio company that essentially refused to hire women. We, as employers, as insurers, we've got to make sure that we understand as employees, when they walk in the workplace, they have to change their behavior. They can't act as they do in their basement. They can't act as they do in the local bar at the bowling alley. I hear so many times, you can't tell me what to do. Yes, we can, because the federal government is telling you how to act. And if you can't get along with that, then you may need to go work elsewhere. So we've got to take some responsibility for changing how this is dealt with in the workplace.
You just need to make sure that you're training consistently and reinforcing those harassment policies. All right. I'm going to race through this last topic, which is medical marijuana. We put medical marijuana last because after all these nightmares, you're going to need your marijuana in order to get to sleep at night. But Arizona recognizes the medical use of marijuana, and Arizona, by statute now, has given medical marijuana qualifying patients some protection from criminal liability and some employment protection. Employment protection that is given is twofold. First is if you have someone who is a medical marijuana card holder, they have a qualifying disease under the marijuana statute and they've registered with the government, as an employer, you can't discriminate against them. So you need to essentially ignore their status as a card holder when you're making employment decisions. You I think should sort of treat them as if they are disabled, with having to make assumptions about things that they aren't able to do. So if you have someone who comes into your workplace is wanting to apply to be a driver and they're a medical marijuana card holder, you can't say, well, then you must use marijuana and therefore I'm not going to give you this job. You can't make that assumption. You can't discriminate against registered card holders in Arizona. The second thing is if somebody has a positive test then and is a registered card holder, you can discipline them for the failing that test alone. You have to have something else. You have to have either their use of marijuana in the workplace, their possession of marijuana in the workplace, or being impaired by marijuana in the workplace. Now, use and possession are pretty easy to figure out. If they're holding or if they're using, there's smoke coming out of the break room as they walk out, then I think you've got them. Impairment is a little more difficult, and the medical marijuana statute does not define impairment. But Arizona has a drug testing law that has a definition of impairment, if you go to the next slide.
That's really small, Gordon.
Yeah, there's a lot on that slide. But I can boil that down to essentially 3 words. No squirrely behavior. So if you see the person stumbling, if you see that they have blood eyes, if they're engaging in squirrely behavior, then that can be a sign of impairment that can be combined with a test to allow you to take action against that employee. So the big thing for you, if you go to the next slide, even before the next slide, is train your supervisors to make note of signs of impairment before you're sending the person for the test, because you want the fact that they're stumbling down the hall and then I sent them for the test and they got positive to show that they were impaired. If you just say, oh, I sent them for the test, and you don't have the other evidence of impairment, you might not be able to take employment action. So you can't discriminate against card holders. If they fail a test, you have to have some other evidence of impairment in order to assess liability. And you should look at your policies to make sure that you are, if you're a private employer, in some circumstance, you prohibit the use of marijuana in the workplace if you want to. You prohibit the possession of marijuana in the workplace if you want to, because you're still authorized in the statute to do those things. And also, you can make some delineation of safety-sensitive positions for which use can be a disqualifying event. So you want to look at the positions and see if you can make some safety sensitive. And I think with that, we'll move on to the questions.
Okay, great. Well, we've had several questions come in. Thank you. Let's go ahead and we'll go through a few of these. This one, like it pertains to social media, how does this affect liability for those entities that produce applications or apps which employers use to monitor employee comments?
Yeah. Well, if you are, the Fair Labor Standards Act prohibits you from retaliating against employees for engaging in protected concerted activity. So if you're, monitoring your private employer and you're monitoring what your employees or what anybody is saying about the company out in the space, the important thing is that if you find out that one of your employees is saying bad things about the company, that you do evaluation of whether that conduct could be considered concerted activity and what kind of action you're going to take against it. If you just have a blanket, oh, they said that we were horrible and we made people work too late and other people joined in, I'm getting rid of all those folks. That is obviously going to violate the law. So I just need to be very careful when you hear employee comments about the company and the social media world, that you can't take automatic action. You need to get some advice and evaluate what steps you want to take.
That same token, I'm assuming that pertains to profanity as well on social media.
If the person is using vulgar and inappropriate language, if they're doing it on a topic that can be considered protected concerted activity, it's still protected, and the fact that they are saying blank and blank that my boss is really blanking unfair because he blanking doesn't let me work, and other people say me too, that's that's still protected even though the communication is not professional.
Okay, thank you. All right, Steve, I think this one's for you. How do you know if the relationship between two employees is enough to support an association retaliation claim?
And that's a really hard answer because we don't know. The Supreme Court said that it's almost always certain that if you've got close family relationship and you're talking termination, that's probably enough in a social retaliation claim. If you're talking just people who just sort of know each other and the discipline wasn't very significant, then we're probably not. He left completely unanswered all the things that are in the middle. So we not only have to look at the nature of the relationship, but we also have, because of the way they put it out there, it's a combination of how close is the relationship and what is the nature of the adverse action. So it's really a case-by-case basis, and I wish I could give everybody a better answer than that, because that sounds like I'm saying you just want me to call a lawyer. Unfortunately, that's the response, is that we have to sit down and really evaluate that, by the way, we're expanding associational retaliation. They're not just applying it in Title VII. They're applying to FMLA, discrimination all over the board.
I see a question on the screen that asks about what is considered de minimis work for smartphones, and like Steve just saying, that is essentially a case-by-case evaluation. But the bigger problem is if you're allowing your non-exempt employees to use smartphones, unless you have a really good way of tracking that time, then the non-exempt employee can go and make a claim, and they can say, "Oh, I was on for I responded to some huge number of texts." I guess we can go back into the records, but the big problem with smartphone usage, and the problem often in Fair Labor Standards Act cases, is the employer isn't tracking the time, and if the employer is not tracking the time, then they don't have a way to disprove what the employer says about the amount of time that they worked.
I think our limitation.
Yeah, I think we are. I think we can take probably a couple more questions after this, but, thank you, Gordon and Steve, for your time today and for your informative and highly entertaining presentation.
I think they'll be the judge of whether it's highly entertaining. Yeah. Please, I hope that you think it was highly entertaining.
Well, just as a reminder, this session has been recorded and will be available online for future viewing. In addition, all of our previous webinars are available on our website. If you would like a copy of the PowerPoint slides, please email Steve, Gordon, or myself. We'd be happy to provide those to you. Thank you again for joining us. We hope you enjoyed the webinar and have a great day.
Thank you very much, y'all.
Thank you
very much.
All right. Do you want to take just two more? I see a couple more questions that came in for those that are still hanging on here. Last one here. What about businesses?
There was a question about businesses that have federal contracts that preclude the use of marijuana. The Marijuana Act, if you have you still comply with federal law. Just being a card holder doesn't mean that the person is using marijuana on the job. So you can't say, okay, I understand that you're a card holder, and I have this, federal regulation. You were in trucking, and we have, federal transportation mandates that prevent this kind of use. So I'm not going to hire you. You would be if you are making an assumption that a card holder is using marijuana on the job, then you could be violating the Arizona Act. If that individual has a positive test, there can be things that are required under the federal law, but the state law says that you have to have some other reason to take action against them. And at least for transportation, the federal law requires you to take them off the position, but it doesn't require you to terminate them. So, that's just a real balance that you have to draw when dealing with medical marijuana users when you're under federal contracts.
And I thought this was an interesting question here that someone else asked. Is a person disabled if a medical condition could be corrected with surgery, like a torn ACL or meniscus, but the employee has chosen not to get that surgery or can't afford it?
Well, that is an interesting question, and I'm interested in Gordon's thoughts on it, too. My sense is, yes, that if that person is disabled, if the condition is such that it constitutes an AA disability, I don't think you can force them to have surgery, especially if they can't afford it. There's all sorts of reasons people don't have surgery. So I'm not sure that saying, well, you're not engaging in that is enough to get you of ADA compliance. You want to engage in that interactive process. You want to see if there's other modalities of treatment that could be less invasive, that could help the problem. And I think you can also require them at some point to engage in something. But I think it's hard to say you've got to go out and get into surgery, and if you don't, we're going to fire you. Yeah. I think that's going to be problematic.
Yeah, if the person has the condition, then your responsibility is to engage in the interactive process and see if it can be accommodated, in some way in your employment. And if you can accommodate the condition without them having to get surgery, then I think that you would have an obligation to do that. There's the need for you to make corrective measures does not extend to, you need to get a surgery to fix that, so I don't have to treat you as disabled. If they have a condition that is preventing them from walking or lifting, then the responsibility of the employer is to engage in the interactive process to see if it can be accommodated.
But, on the other hand, if after engaging in the interactive process, there truly is not a reasonable accommodation, and that person, given their refusal to get treatment, cannot perform the essential functions of the job, then you have grounds for letting them go. And because you have, the reality is that this disability continues to exist, there is no reasonable accommodation, and while you can't force them to get the surgery, if they can't do the essential function of the job, then you can let go. So there is some protection there.
Right. And remember that the accommodation just needs to be a reasonable one. It doesn't need to be the accommodation that the employee wants. So if there's something that you could do that would allow the employee to do the job, but it's not, all the bells and whistles that they're looking for, as long as it would allow them to do the essential functions and you offer that accommodation, then you've met your obligation to the employee.
Great. Well, so again, looks like we've addressed all the questions that came in. Again, if you have any follow-up questions, please feel free to contact one of us, and thank you for those of you who stayed on a couple minutes extra here to hear the rest of this. So thank you again, everyone. Have a great day, and thank you to Stephen Gordon.
All right.
All right.